Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Today it's my pleasure to review another book from the Legal Action Group. That's the Access to Justice charity. It's an organisation that I've been associated with for some time, and I enjoy certainly reviewing the books that they publish, but also using them because they're very important books. And they're very important for a number of reasons. One is that they're very easy to read and use, and they're very helpful, of course, for unrepresented parties. I'll come on to that in a minute. This book is in an area which I think is very directly relevant to litigants in person. It's employment law. It's a very popular book, this one. It's an advisor's handbook, and it's now in a 12th edition from Tamara Lewis. Tamara's produced really first-class work here, and as I say, LAG are to be congratulated on producing this work. Elizabeth and I talked about the book, and for our book review title, we've given it a most important new edition on employment law for 2017 from LAG. Pretty straightforward, but what I would advise you to do is do have a look for our reviews in the local journals and also on the web, because these books are very important, and they are normally you will find them in the courts and in the tribunals. Let's look at this book. Nice picture on the front there, and you can see that's the actual title. Then there's the spine, and then you can see the back. There are some quotes from various organisations and journals there. Then you've got the actual commentary about the book, some of which I've used because when I'm writing the review you won't have this information in the journal, so it's useful to have just a quote or two from what is being said. You can see that it's the 12th edition, and if you look at the side you see there's a shaded area, and that shaded area, which is the appendices, that shaded area is quite important because it gives you, in Appendix A, it starts off, that's a checklist, and you can see it's very, very important because it gives you all of the simple things that you have to do. Now the book's expanding, as usual, they all are. The actual index, which is at the back, is a useful, fairly substantial one, actually cited by paragraph numbering. So it's the chapter and the paragraph numbering if you're looking for anything. And if you get to the front of the index, you can see it doesn't say that, but that's what it is. It's actual paragraph numbering. Then after that, you've got the appendix. I think there's 6 appendices in total, bibliography and so forth, useful addresses, but all the usual stuff that you want to see. If we go to the front of the book, it runs to nearly 1,000 pages, believe it or not. It's getting to be a big book. So it talks about Tamara. She brings 25 years of experience of working as a solicitor in the employment unit of the Central London Law Centre. So she's seen a lot of problems over the years, and you can see the book is available as a book and an ebook. This is a paperback, this one, but it is a book that I see regularly in the courts and the tribunals, as we do with all the LAG books. And you should find this in public libraries as well. Do read the preface, which Tamara has set out, basically trying to state where we are. I shall borrow a little bit of what she says from there in a minute. Then there are acknowledgements. Then you've got the contents section. It's always, as with LAG, a very detailed set of contents. You can see how they run through everything there. Then after the detailed contents there, which I'm just running through, you can see the number of chapters. There are a total of 22 chapters, and then there are the 6 appendices, and then the index. Then you have a table of cases, quite a lot of case law, which runs through for a while. And after the case law, you've got the table of statutes, again, quite a few of them. Then you've got statutory instruments after that. And then after that, I mustn't miss out the table of EU legislation. Now, being a Remainer, not a Ramona, but a Remainer, I'm going to say again that we are leaving, but you're still going to have the EU legislation for some time to come. So, Brexit people, beware. It's still going to be there. Then you've got the table of international legislation, which is going to be with us whether you like it or not. It's as simple as that. And then you've got abbreviations. I shouldn't be so frivolous with some of this, but the Brexiteers have got what they want, but we've got to pick up some of the pieces. There's the abbreviations, and then we get into the various parts. So once you've got an introduction, and then you see the structure, you've got an index of what's actually in the chapter, and then you get, after that, you get some standout sections which give you the key points, shaded boxes, and so forth. And then it's paragraph numbering, because that's how the referencing is done at the back. You do have, as you can see, just going through, quite a lot of footnotes, not too much, but the footnotes give you quite a lot of information. Then it runs all the way through. Evidence in discrimination cases is always important, and so forth. A very good book, very popular, and you can gather it's popular because it's the 12th edition. Now, what do we say about it? We're delighted to review another edition of what is a splendid and informative guide from LAG, the Legal Action Group, written by Tamara Lewis, and called Employment Law and Advisor's Handbook. And as I say, it's now in the 12th edition, so very popular. It gives us as advisors up-to-date coverage of both the United Kingdom and European employment and discrimination law. And I think it'll be very useful for unrepresented parties in the post-LASPO era where there's no legal aid. It may be that things change with the Back Commission, I don't know, but the fact is at the moment we are living in an era where there's been a lot of tinkering with employment law, the practice and the procedures. There's been attempts to all sorts of things which you all know about, fee levels and so forth. But at the moment we did see a big drop, but we're now seeing, as I'm told, an increase now. So the levels of people who are litigating within employment law issues has risen. It won't go away because there's going to always be bullying in the workplace and disgraceful behaviour by employers, and therefore you do need to have some mechanism to right the wrongs that are committed. Now, what we find most useful about this book are the clear and succinct commentaries on case law which we get. We've come to rely on them, plus a thorough consideration of the relevant domestic legislation, the European Union treaties and the directives, which are going to have been fully updated for 2017. As I said, and I made the comment, we're leaving the EU, but that doesn't mean to say that anything's going to change overnight. And I think that most of what we've got is going to be with us for a long time to come. Now, do read the preface from Tamara at the beginning, which sets out what changes she's actually highlighted, which have occurred since the cuts of 2010, mainly because the landscape in employment law has changed. And I suspect, I have to say, I think it will probably change again, because whilst we are having these changes with our relationship with Europe, it is to be hoped, and I say this as an optimist, that most of what we've actually got by way of the protections for employees will remain. That may not be the case, but we'll have to wait and see. I'm hoping that it will, because at the moment we are planning with the legislation withdrawal from the EU legislation that we will be able to maintain most of the rights that we currently have. Obviously some will go, but it's a matter for Parliament at the end of the day. Now, Tamara does mention the use that you can make of the internet as an additional invaluable access source for reports, guidance and codes, and I'm glad she's done that, because that's the future for an awful lot of these publications. And there's a word of warning, of course, which I will remind people of again, because the access can be badly signposted, sometimes hard to find on host websites, but do persevere with what you're looking for. I have found it a nightmare, frankly, with some of them. I found the Ministry of Justice website not the easiest to handle, but I'm not particularly computer savvy myself. But the thing is, you've got to know how to use it. Rather, you've got to know how to use the white book or the family law red book or whatever. You have to know your way around, and it's only practice that makes perfect. Now, one of the important aspects of LAG publications are the structure of the works that they produce. This publication was written to fill a gap when advisors had been asked to recommend a suitable employment law text, and we think, based on what they've come up with, that this is the best short work on the market at the present time. Here we have a step-by-step guide which is so useful for advisors involved in unfair dismissal and discrimination cases. And as I say, when they were originally asked to advise on what book would you go to, there wasn't one, and that's why this book sort of germinated, if you like. Now, Tamara has given much space to areas where the main questions arise: evidence, precedents and checklists which set out the law as it is today. And each chapter starts with a useful summary of key points, and there's an extensive cross-referencing throughout. The main texts are supported by practical resources including sample case papers, a glossary and signposts to other sources of information. And the new edition aims to set out the current position following the abolition of the employment tribunal fees, all of the problems we've had with that, new case law on ACAS early conciliation procedure, the latest on discrimination compensation, including the updating of the Vento guidelines, and substantial case law that's developed on the definition of disability discrimination under the Equality Act. Now, I've taken that part from the book because that will not appear. Obviously, it will appear in some areas where I've produced the reviews, but in the written reviews in the journals, you need to have some idea of what is new in this particular edition. Let me conclude by saying that the book remains for us an essential, short and easy to read guide to employment law for all claimant advisors, trade union reps, lawyers, and any individual looking for a comprehensive yet accessible guide to employment law at a time of worrying change. And it does make our lives easier, and no question about that. And it's not just me saying that as an advocate. I think it assists the decision makers, the judiciary, the tribunals. This sort of work does help because it's a very difficult, very complex society that we now have, and we do need to have as much help as we can. The publication date for this edition is cited as at the 31st of October 2017, and I'm recording it in November of 2017. Big thank you to Tamara. Thank you to everybody at LAG. I can't name them. I know that you know who you are. You do a wonderful job for us, so thank you from the bottom of my heart and that of practitioners and decision makers. We're very grateful to have this continued service from you. Thank you. Bye-bye.